Madam Clerk, Resolution 113.
Resolution 113-13 commits to funding the cost items agreed upon by the employers and the United Public Workers, UPW Unit 1, and employees excluded from bargaining Unit 1 for the contract period July 1st, 2013 through June 30, 2017. Cost items are across-the-board increases and changes standby work compensation from $2 per hour to 25% of daily rate. Estimated cost to the county will be $10,924,846 for blue-collar employees included in bargaining Unit 1 and $111,717 for blue-collar employees excluded from bargaining Unit 1 for a total of $11,036,563 introduced by Ms. Poindexter, waived Finance Committee, and Communication 276.1 from Finance Committee Chair Valerie T. Poindexter dated May 16, 2013, requesting that this matter be waived to Council for immediate action.
Thank you. May I have a motion to approve Resolution 113?
So moved.
Okay, moved by Ms. Poindexter, second by Mr. Onishi. I'll just let council members know Ron Takahashi is available in Hilo if you have any questions to Mr. Onishi.
Thank you, Madam Chair. Ron, can you please come up? You can introduce yourself. Ron, you can introduce yourself.
Hi, good morning. Ron Takahashi, Director of Human Resources.
Thank you, Ron. Thank you for coming up. Can you just explain to the public on, I guess, the protocol when there's, I guess, bargaining, I guess, agreements between the unions and the administrations?
I'm not quite sure what you're asking, the protocol, but if you're talking about the resolution before you, or go ahead.
Okay, so this is because, okay, what's in front of us is to approve the increases for their, I guess, the negotiated bargaining, I guess, between the employees and, well, the union and the administration, the government, correct?
Correct.
Okay, so what I'm saying is, if you could explain to the public on what is the procedure, like, it's like, because of this agreement, we as the county council really cannot reject this off or reject this contract, correct?
Okay, the protocol is whenever there is an agreement that involves an increase to costs that requires appropriations by the various legislative bodies, those increases to costs, like in this case, there was an increase to wages and there's increase to the standby pay for these employees in bargaining unit 1. So the law requires that each legislative body, the state legislature and the county councils of all the various counties must approve these cost increases. If one or more body rejects the items or not approve them, technically there is no agreement, and the parties are then required to go back to the tables and start negotiating again. Does that answer your question?
Yeah. Okay. Yeah. Thank you. Yeah. So like this is I guess different from arbitration.
Correct. This agreement was done through negotiations. Unit 1 does not have arbitration as its to resolve their resolution. So this was agreement. So yeah, this requires a approval by the county council. This is approved or not approved.
Right, and then so now if we didn't approve it, then they would have to go into arbitration.
No, again, Unit 1 does not have arbitration. Unit 1 by law has, the right to strike.
So
which the other bargaining units which has arbitration does not. So.
Oh, I see. Okay. I know like HGA, they do have arbitration, correct?
Correct.
Yeah, okay. Okay. Thank you. Thank you very much for your explanation.
Thank you. Ms. Wille.
Let me say I trust in the mayor in terms of reaching agreed upon rates, but at the same time, I do agree with the testimony of Cheryl King that it would be good to get a clarification that the county will enforce its own ethics rule, which prohibits the use of county time equipment and other facilities for private business. When the Ethics Commission heard the complaint on this point, rather than upholding its own ethics law, as the chairman would have had it in his vote, it said, no, we're leaving this for the county to work out with the unions, and that the union contract, or the county's contract with the union, trumps county law, which, as a lawyer, is a ridiculous statement in my mind, and I don't think there's any state law that said otherwise. But basically, since that was how our commission said, let's resolve this issue on the contract level and let the mayor or the county clarify that it will uphold its law, I think that it would be important to either get a clarification from the administration or corporation counsel that this point has been made, which Ms. King was unable to obtain in inquiring from the mayor's office. And I guess my point here is it's just we don't want to be looked at as disregarding our own laws. I don't think that this is an issue that the union is there to enforce. It's really for us as a county to say this is our law and we uphold it and we intend to enforce it, and not have campaigning of certain candidates in county facilities. I do want to admit that I have a bias. I'm not sure bias is the right word, but since it was my opposition who was selected to go to the county offices and be courted there for the unions and others over numerous occasions during that period, I clearly felt it was unfair and did testify. And again, I made it very clear that this was not anti-union sentiment. It was just that we as a county need to get this clear that we enforce our ethics law. So I don't know whether, Margaret, you're here, or there could be some clarification as to the county's position on this issue.
What is your specific question?
So on the
Mr. Ashida, introduce yourself.
Oh, thank you, Madam Chair. Lincoln Ashida, Corporation Counsel. Good morning,
so,
Ms. Wille.
Lincoln, just my sense, and I'm oversimplifying, but that the Commission seemed to indicate that the way they wanted this resolved, in other words, what is compliance with our ethics provision that says, and I'm quoting, using county time equipment or other facilities for private business or campaign purposes is prohibited. So just to get clarification on this issue, since this is the negotiated contract, can we find out if this has been clarified that we will be enforcing this, or that we're sort of allowing it to be thought that that county contract does not support this and is trumping our county law?
I see. Your question is whether the practice of, I guess, having these union meetings with endorsed candidates, whether that will continue in the future.
I can't, can you move a little bit away? Sure. I just can't understand.
The question is whether this practice or this occurrence of having union membership meetings with endorsed candidates present will continue in the future. Is that what I hear you asking?
Well, that's for practical purposes. If you want to answer it that way, that would be, if you say no, we're enforcing the law, I'm fine with that.
Well, we enforce the law, I mean, no matter what the circumstances are, but what you're saying in this case, it's the ethics board had said that they were deferring to, or they were not they were not going to hear it, or they're not going to make a decision?
Yeah, they brought, I believe it was Renee Schoen forward and asked her, Corporation Counsel, her as representing the county, after consulting with her, then came out with, well, we'll leave this for union negotiations rather than, it was a split decision, so there was really two.
I apologize. I wasn't following it. I'm not very knowledgeable. But I can talk to Renee. I can find out. I'll get back with you.
Okay, can I ask Cheryl King, who was the one that brought the complaint, can you come up, Cheryl, too?
Madam Chair.
Yeah.
Ms. Willie, sorry, I'm going to make a point of order.
Thank you.
I'm just going to bring it to the Council's attention. I'm not confident that this topic is on topic with the particular resolution. So I just want to throw caution here, because if we're talking about something that's not on the agenda and not as reasonably expected to be discussed as part of this, then, we would be in violation of the Sunshine Law. I mean, if it specifically is a requirement saying, oh, we want this particular concern to be addressed, Ms. Willie, then I think we're on safe ground. But I think we're kind of stretching it a little wide here. So just, council members, just food for thought. I think we're talking about approving a contract that was negotiated. So anyway, and I don't know if Mr. Ashida wants to weigh in on the Sunshine Law aspect of the concern.
Since you asked, technically, actually what the council is doing is not per se endorsing or approving an agreement. If you look at the statute carefully, all the council is doing is making the appropriation. That's made clear in the HRS, because technically it's only the mayors as the employers who can make the agreements. The extent the council's authority in matters such as this is the appropriating body of the funds necessary for the consummated collective bargaining public sector contracts. To me, that's the issue before the council. It's a money issue. But since you asked.
Thank you, Mr. Ashida. I actually was concerned about that during the public testimony, because Ms. King, I thought, was speaking on a sort of related but not really the issue on our agenda. So at this point, I'd like to keep our discussion.
I'd like to, though, respond to that.
Excuse me. Excuse me, Ms. King.
Yeah, so in terms of that and the relationship to the appropriation, Cheryl, do you have a comment?
Yes, I want to clarify what actually happened. At the end of the ethics meeting, commission, at which this petition was brought.
But our item on the agenda is not regarding whether the union's policy of having meetings and inviting candidates is not our agenda item. So
no, but that's why I did not support it, because there was no
thank you.
But could I clarify what really happened? Because there is
I'd like to not get into the discussion regarding the Board of Ethics or the issue.
I'd like to comment on that. I'd like to comment on it, because it was the commission that threw it back.
Point of order.
But that's not what we're discussing on our agenda today.
I'm not here to violate Sunshine Law or anything. This is in point of order.
My suggestion is that we table this and
excuse me, I'm going to ask Ms. Poindexter right now to comment.
Yeah, I'm going to comment on this because union contracts, it's not only with the employee union, we're the National Labor Relations Board that we have to abide by all those rules also. I previously came from a job as a HR manager, and I dealt with a union contract. And I'll just give you an example so it can be real clear. Federal Labor Standards Act, 40 hours a week, anything over that constitutes overtime pay. That's the Federal Labor Standards Act, the FLSA. The union contract, which I was helping to actually just helping to guide there at the company that I was at, the contract stated 8 hours, anything over 8 hours a day constituted overtime for any employee. So guess what? The union contracted trumped the Federal Labor Standards Act of 40 hours per week, anything over that.
Excuse me, Ms. Poindexter. I'm trying to stay on the topic of
but I'm just trying to just trying to make them understand that
we can have this discussion when we bring another issue forward to the council.
Okay.
I'd like to keep it to the issue at hand.
Madam Chair.
Thank you. Mr. Kern.
The issue at hand is to appropriate funds or not appropriate funds.
Correct.
And we should be discussing on that or voting on that, that's already been negotiated. We can't come and start trying to renegotiate afterwards. Do we appropriate? Do we not appropriate? We should vote.
And this other discussion can be brought forward at a different time. Yes. Thank you. Okay, is there any further discussion on the resolution? Ms. Ford.
Thank you. First, I want to say that I would love to be able to support this, but we're playing semantics here over this. And while it does say that this is basically it's a funding, the word is funding the cost items negotiated in this agreement, there are reasons that I can't bring myself to vote for it, and they have already been discussed, and I won't go there. But the semantics part of it is, if we appropriate this, the mayor is going to sign it, and it's a done deal. And you can't negotiate a new contract after you've signed a contract. You have to wait till the next bargaining session comes up. This is the only opportunity. So I will not support this at this time. Thank you.
Mr. Kanuha?
I need a clarification. Who negotiates the contracts?
Mr. Ashida, can you help out?
The mayor negotiates the contracts.
Or would you prefer I ask Ron Takahashi?
It's a simple question. I want the public to know who negotiates the contracts.
For state of Hawaii public sector contracts, it's the governor and the mayor. It's my understanding. Ron can check me. The governor has 4 votes. Each of the county mayors has 1 vote apiece. They are designated under our state law as the employer responsible for negotiating in collective bargaining.
Thank you.
Ron, is that right?
That is correct.
This is just for the public's benefit. Thank you.
I have a question for Mr. Takahashi.
Ms. Poindexter?
Mr. Takahashi, isn't it true that even if the contract is signed, that there's a good faith through National Labor Relations Board that both sides can go in and come in with a supplemental into the contract, correct?
Yes. Once a master agreement is signed and agreed upon, each jurisdiction, and it's through the state law that's governed by the Hawaii Labor Relations Board, can negotiate supplemental agreements in addition to the master agreement, yes.
So in other words, that even if we vote this through, should something else come up, there is a possibility for another supplemental into that agreement, a possibility for that?
Yes.
Okay. And the reason why I'm supporting this is the unions have done furlough days for a long time. I know a lot of union employees who had taken a hit on this and took less pay because of the furloughs. And I think, when we look at fair labor, wages, I feel this is fair. I don't want to move backwards into the plantation days of the sugar companies and we had to fight for something. Not passing this too, we stand the risk of a strike if we have an impasse. Is that correct, Mr. Takahashi?
That is a possibility, yes.
Thank you. So I'm supporting this. Thank you.
Thank you, Ms. Ford.
Thank you. As I said earlier, for me personally, I want to support this. I believe that the union workers deserve it for all the reasons Ms. Poindexter said. And I do not believe that we're going back to plantation days if we ask for reasonable things in contracts, which I'm, again, not going to discuss at this point in time. But based on the complaints I received from union people over some issues which I won't discuss, those union people felt very put upon to be forced to a meeting. So I'm going to say no to this appropriation because it is not adequate. Thank you.
Ms. Wille?
Yeah, I wish the mayor could clarify. This discussion may all be moot, and that he made this clarification in the agreement, and just because he was unavailable to comment, we're here discussing it. Again, I want to say I really appreciate the terms of this contract and support the union members, and it was numerous union members that came to me complaining about this particular provision, and they were sort of in a position it's important
point of order, we're still talking about.
So I'm not going to support this. I just want to make clear the reason that I'm not supporting it, and
thank you.
That's why.
Mr. Yoshimoto, any further discussion? Okay. Thank you, Madam Clerk.
Ms. Ford?
No.
Mr. Kanuha?
Aye.
Mr. Kern?
Aye.
Mr. Onishi?
Aye.
Ms. Poindexter?
Aye.
Ms. Wille?
No.
Mr. Yoshimoto?
Aye.
Chair Eoff?
Aye.
Chair Eoff, you have 6 ayes.
Thank you. I'm going to take a 5-minute recess at this time. We're in recess.